All right, well, good afternoon, everybody, and welcome to our first webinar in the Canadian Trademark Series. I'm Elliot Gould, and I'm a principal in the Trademarks group at Smart & Biggar. Together with my colleague, Mika Ellis, I'll be one of your speakers for today's presentation on trademark issues and strategic considerations for Canadian SMEs. And hopefully everybody here is a small to medium enterprise. I know some of you are other, and I hope we can give you some important information as well. So the goal today is to present relevant information for you to take away and understand trademarks a little better. So the presentation will last about 40 minutes, and we'll have an interactive question and answer session where we'll try to address questions you have at the end. You're welcome to submit questions through the Q&A link at the bottom of your screen. Please don't use the chat panel. We'll try to address as many questions as we can during the session, and if we can't, we'll get to it with an email afterwards. The webinar today is going to be recorded, and we'll circulate an email with a replay link along with a PDF copy of the slides. At the end of the webinar, there's going to be a survey, and we'd appreciate if you could take a few minutes to complete the survey with your feedback about how it went today and what topics you'd be interested in learning about. So before we begin the webinar today, we'd like to offer a land acknowledgement. In the spirit of reconciliation, we respectfully recognize and acknowledge that the land we are meeting on and that all Canadians live on, work, and enjoy is the traditional territory of many nations. These lands are now home to many diverse First Nations, Inuit, and Métis people, and are covered by various land treaties. In Toronto, where I am, the land is the traditional territory of the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is covered by Treaty 13.
And I'm coming to you from the unceded and unsurrendered territory of the Algonquin and Anishinaabe, currently called Ottawa.
Thanks, Mika. And so we'll start with a brief introduction of Smart & Biggar. We're Canada's leading IP firm with expertise at the interface of technology and business law. We have expertise in all areas of IP, patents, trademarks, copyright. We've been around for 130 years, serving clients, Canadian and from around the world. We have 125 plus lawyers, agents, and technical consultants. We file approximately 12,000 plus patent and trademarks annually. And we're proud of our litigation bench strength and record of success. And the trademarks litigation groups consistently ranked as the top firm in Canada. So over to Mika to start. Oh, now I guess we're the next slide, please. Let's just summarize what we're going to cover today, and hopefully we'll get through it all and we don't run out of time. This is all really important stuff. We want to make sure we get to it. So I'm going to cover what is a trademark, how to choose a strong one, the basics of searching, the process, timing, and cost for registering. We'll talk a little bit about brand value and funding trademark protection, enforcing and defending your rights. An important slide about doing business in Quebec. There's some important changes coming in that regard, and we'll try to set out some key points to educate your employees about trademarks. And the takeaway message in this age of shortened attention spans for all of us, if you're going to pay attention to this slide. Our takeaway message: choose a clean trademark, clean being not being used by a third party. Use your mark properly. We'll get into what that means, or you lose rights to it. It's important to police your brand, make sure that you're looking after the marketplace of infringers. And we'll talk a little bit about studying industry leaders as a guide to how to do things properly and in an ideal way. So with that in mind, I guess Mika can start.
So great, thanks, Elliot. I guess the first question is, what is a trademark? A trademark is a source identifier, and these are important things to keep in mind when you're considering your trademark, when you're considering the strength of your trademark. So we're setting out what a trademark is first. So it's a source identifier. It identifies you, or it identifies the owner as the source, helping to distinguish the goods and services from one business of another. So if you, for example, look at two laptops, and one laptop has an Apple trademark on it, and the other laptop has a Macintosh trademark on it, then you know that one of them will give you different types of services and programs and quality than the other. And so you might choose one laptop over the other. So a trademark is a source identifier, and it informs the consumer what they can expect when they engage with that good or service. What is a trademark? A trademark can take a number of different forms, and we actually expanded the definition a few years ago in the Trademarks Act. So a trademark can be a word or letter, so it can be something like Apple, it can be McDonald's, it can be a symbol, so it can be the big letter M for McDonald's, it can be a design, it can be a color, it can be a three-dimensional shape, like the shape of the Coca-Cola bottle. It can be a sound, like the MGM Lions roar, or it can even be a smell. And the smell, the example that I was thinking of is the smell of Play-Doh, that little yellow box, when you open it up and has a very distinctive smell, that can also be a trademark. So you can get really creative with your trademark. But how do you choose a strong trademark? There are some questions that we think are important to ask when you're choosing a strong trademark, to decide whether or not you want to pursue that trademark as your main branding. So one question you can ask is my trademark primarily merely a name or a surname? If it is, it would be considered a weak trademark, and if you're planning on registering it, would be considered unregistrable, unless you can establish that you have used it in the market for a long period of time and have acquired a specific reputation. So you have extensive use in the marketplace. Without that extensive use, though, it would be a weak trademark. Another type of trademark that would be considered weak would be if your trademark is clearly descriptive or deceptively misdescriptive. So if you look at your trademark, like say you're trying to trademark apples, and you decided you want to use the trademark orange because it's cute and ironic. Well, unfortunately, the trademarks office won't think that's cute and ironic, and that would be considered clearly descriptive, or deceptively misdescriptive. Actually, it'd be deceptively misdescriptive because an apple is not an orange, so you'd confuse the consumer, and it would just be a weak trademark. Another weak trademark would be one that's confusing with an already registered or pending trademark. So if you, for example, want to use the trademark Yapple with phones, that'd be a weak trademark, and actually you'd probably be sued by Apple because Apple would come after you, or you'd confuse the consumer base such that your goods and services wouldn't gain their own reputation in the marketplace. So if you're primarily merely a name, if you're clearly descriptive or misdescriptive, or if you're confusing, those are all really weak trademarks to register. So, or to have, you don't necessarily have to register. We'll talk about that in a second. So what kind of trademark do you want? You want to choose an inherently distinctive trademark. What is an inherently distinctive trademark? Well, inherent distinctiveness can be measured on a scale. Some inherently distinctive trademarks are incredibly strong. So that would be something like a coined word, such as Google or Kodak. They're words that have no meaning and they have no definition. They're just made up, and you can use those as a brand. Another type of inherently distinctive word would be an arbitrary word. So in the case of Apple, Apple has a definition. It's a fruit, but when used in association with computers, it means absolutely nothing. So that can be inherently distinctive trademark when used in association with computers. You can also have a trademark that fits anywhere between, we have the spectrum set out on the screen in front of you, between the orange, the yellow, and the green, where it can be slightly weaker. As long as you sit on the scale though, you have some level of inherent distinctiveness, you have some level of registrability. So for example, what would be on the lower end, but would still be registrable? If something like juicy rounds for apples might be considered on the lower end because it's a little bit descriptive, it's describing the apple as juicy and round, but also it may just merely be suggestive because you have to think a little bit when you're thinking about the trademark. Whereas if we're on the upper end, like Macintosh for apples, Macintosh doesn't describe, I'm not really sure what the word means, it's a strong trademark. There are trademarks that have no inherent distinctiveness, and those are the ones that we talked about in the previous slide. So the first 3 bullet points. If you want to be competitive in the marketplace, you may want to find a trademark on the upper end of this spectrum of inherent distinctiveness. And I think Elliot has something that he would like to say to that.
Thanks, Mika. No, I just wanted to bring to everyone's attention this very busy slide, which shows brand value. So the most valuable brands in the world for 2024. And if you look, what do you see? I mean, if you look closely, and the link's at the bottom, so you can look even closer afterwards, what I see is large numbers attached to these brands. First of all, like that's not the value of the company, that's the value attached to the brand. So the brand Apple is valued at, $500 billion. So if you look all around, you see high value. But what do I see? I see industry leaders in various areas. And I also see highly distinctive brands. So all the things Mika's talking about, the best, most successful companies have chosen distinctive brands. And what that allows for is that there's a blank slate for what the trademark means, and you can create the meaning that attaches to your company. So it's not that you have to fight to create a meaning that for a word that already has a meaning. And for various reasons, when you have these words, they're much easier to enforce against infringers. The more descriptive words are very hard to enforce. Exclusivity, it's hard to stop someone from using the word computer if they're a computer company. So that I just wanted to bring your attention to this slide and the distinctiveness of these brands. Back to you.
So now that we have an idea about distinctiveness, one of the other things we mentioned is your mark confusing? So how do you know if your mark is confusing with another trademark in the marketplace? Or if your potential brand that you're trying to research might potentially be confusing with another. And there are various resources that are publicly available that you can use while you're trying to decide which brand or trademark you want to come up with. CIPO, for example, the Canadian Intellectual Property Office, has a publicly available trademarks register. So you can search, the link is on the slide, or you can just go to Google and say Canadian Trademark Database, and it'll be one of the first 2 links that pops up. And you can go onto that link, or you can go to the USPTO, which is the US Patent and Trademarks Office. You can say USPTO Trademarks Database. They have a publicly available database. Europe has a publicly available database. Many countries do. So depending on which country you want to enter, might depend on if you want to discover or not, if they have a publicly available trademarks database. Some of them don't, and that's where you would need an advisor to try and search a database that's not publicly available. But you can go onto that database and plug in various words and search and see how those words are used. And sometimes you can narrow the search to add different goods and services. So my example of Yapple for phones, you can type in the trademark Yapple in the search bar, and then you can narrow your search to goods and describe the goods as phones, and then see if there are any trademarks that might potentially be confusing with that trademark. What's also smart is to break down your trademark into various elements that might make your trademark distinctive. So what I've shown here is you might want to search Yapple, Apple, Yap, or Yap in Yap with a space between like you might want to just, by searching it in various ways, you might capture trademarks that don't necessarily look identical, but are very similar. And so that would allow you to see a fuller range of what's on the register. If you just search in Canada, you're only going to get Canadian registered trademarks. So if you plan on creating a global brand, it's good to expand your searches to either global databases, and there is no global trademark database, but there is the WIPO, and you can go through WIPO and they might give you some resources. WIPO is the World Intellectual Property Office, and they have various resources that you can use if you're wanting to see how you can trademark get your trademark into to several other countries at once, which I'll talk about in a second. Regardless of what you do, it's wise to consult a trademarks expert before you launch, because you can do as thorough a search as you think, but we might have other resources up our sleeves or other ideas up our sleeves that might catch something that you don't catch. So even if you've done a full search, you can bring your search to us and say, hey, do you think there's anything that needs to be flagged? Do you have any advice on how I can make sure that my search is fulsome? You may want to consider searching, regardless if you want to register, because you can also search on the, you can have common law rights in a trademark, which means that your trademark isn't registered, but you start using a trademark in the marketplace and acquire rights through your use in the marketplace. So other people may have done the same. They may have started using their trademark, not registered it, but have extensive use in the marketplace. So the Canadian Trademarks Register isn't going to capture anything that's not registered, which means you might want to perform searches like Google searches, or I don't know if we still flip through Yellow Pages, or take a look at business names, and just the other resources where a trademark might be used that's not necessarily registered. What's the difference between a registered trademark and a common law trademark? A common law trademark, you do have rights in it, but you only have rights where you use it. So they're geographically harnessed, which means if you only use your trademark in Ontario, you only have rights in that trademark in Ontario. Whereas if you register your trademark, you have rights across Canada. Common law trademarks are only available in common law countries, and of course, only in the country that you use it. So like the US, Canada, UK, Australia, etc., they're all common law countries. So if you use your trademark in each of those countries, then you might have common law rights. If you register your trademark, even if you haven't used it, you would have rights to assert in those countries, including Canada. So a registered trademark provides you with an increased ability to deter others from using through ways like I mentioned the online databases. Either other owners, trademark owners might search the databases, see your trademark and say, oh, okay, I shouldn't use this trademark because somebody else is using it. Or when your trademark undergoes examination, an examiner within the trademarks office might flag it and say, hey, there's already a trademark on the register. So new person who's trying to register your trademark, you cannot register it because there's a previously registered confusing trademark to yours. So it acted, the registration gives you good deterrence. Registered trademarks also give you increased defense to an infringement or passing off claim, which Elliot will talk about a bit later. And it also makes it easier to bring a lawsuit. A common law trademark, you're only able to assert passing off, which is a very high bar, a high burden for you to overcome in order to assert passing off, whereas infringement isn't going to be as high of a burden for you to assert. Again, I think Elliot will be going into that a little bit later in the presentation. To register your trademark, it's a little bit of a process, especially in Canada. It takes a little bit of time, and there's a little bit of money. So the process is 5 steps, but step 4 may or may not happen. So first, you apply for your trademark. So you need to apply for your trademark, you need to consider what's required, and that would be your name, address, a rendering of your trademarks, and a finalized rendering of your trademark. Some people ask, can I put forward my trademark and make some changes later? You cannot make changes to your trademark after you have filed it with the office. You will also want a statement of goods and services in ordinary commercial terms. So when you file your trademark, the statement of goods and services that accompanies your trademark cannot be broadened once you filed it. So you want to be very clear on how you may want to use your trademark. You are able to delete goods and services. So you can put a selection of goods and services that you may want to use and then realize 6 months down the road, I'm not going to use these goods, so I'd like to delete them. That's okay. You just can't add trademarks, or you can't add goods and services. When filing, you may want to consider if you want to enter other markets. So you may want to consider, are you wanting to enter the US? Are you wanting to enter globally? So are you wanting to enter well over 5 other countries? Or are you just wanting to register nationally? So you're just wanting to register in Canada. If you're wanting to register just in Canada, you don't have that much to think about, and we can get your trademark one pretty quickly. If you're wanting to register in other countries, then there are various things that you may want to consider that we don't have that much time to go into today, but I'll briefly touch on, which is you have 6 months from the date of filing in Canada to file in any other country, or most other countries, and still gain the priority date of Canada. So what does priority mean? It means if I file in Canada today on March 21st, and I want to defer costs a little bit for me to file in the US, then 5 months from now, or like what would that be? I can't do quick math. So like maybe in June, you're like, okay, I'm going to file my US trademark now. Even though you filed that US trademark in June, it will still appear as if you filed it on March 21st if you claim the priority date of your Canadian trademark. So that's one thing to consider. The other thing to consider internationally is that we have this international protocol called the Madrid Protocol. And that allows you to file one international application and designate several other countries that you will want your trademark to enter into. And that will both defer some costs, but also decrease the cost because you're filing one core application that will then be split into other countries. If you have questions on that, definitely feel free to ask Elliot and I. And like I mentioned, I'm just not sure we have time to go into too much depth, but feel free to ask us questions in the Q&A box. So what happens after you file? Your trademark undergoes examination. So in the examiner's office or the trademark's office, an examiner takes a look at your trademark and assesses. Is it compliant on a formality level? So are the goods and services clear? Is there an applicant? Is there an address? And is the trademark, is what you want to trademark trademarkable? So is it primarily merely a name? If it is, you might get an objection. Is it clearly descriptive? That might get you a substantive objection. Is it confusing with another trademark on the register? Or is your trademark not inherently distinctive? So not inherently distinctive trademark would be something that is, for example, clearly descriptive. Unfortunately, in Canada, examination is currently incredibly slow. So it can take up to 50 months for examination to occur. Examination is quicker if you have a Madrid application. Examination can also be accelerated in one of two ways. So if you're contemplating a court action for infringement, if you're trying to combat counterfeit goods entering the country, or if you need to protect rights in online marketplaces, we can present the Trademarks Office with an affidavit and request that there be expedited examination. Another way is to amend the goods and services to approved goods and services that are set out in the Goods and Services Manual. There may potentially be good news that as CIPO has hired 100 new examiners, so hopefully in the next few months, examination time is being done. The last three steps are if once you make it past examination, then your mark is advertised. Your mark is advertised for 2 months. During that 2-month period, someone has the opportunity to oppose your trademark. And they might oppose it if they want to assert that you are not entitled to your trademark because their trademark was filed first and your trademark is confusingly similar with theirs. They might oppose it because they claim that you filed it in bad faith, or for any number of reasons that are actually set out in the Trademarks Act. So it's not just any old reason. There are specific grounds on which someone can oppose. It's not often, there are many oppositions, but it's not often that oppositions happen. I wouldn't say that it happens in the majority of applications. So if you make it past that 2-month period without an opposition, or if you do get an opposition and we succeed in it, then your trademark goes to registration. Now you've registered your trademark, and as long as you use it in the marketplace, so as long as you use it on your goods or with services in the normal course of trade, which means during a commercial transaction, or in the case of services, if you use the trademark on advertising, then that's considered use, and you can maintain your protection across Canada, and that protection can last indefinitely as long as you pay the Trademarks Office your maintenance and renewal fees every 10 years. So that's the life cycle, or that's the process, timing, and cost of filing a trademark. And Elliot's going to give you some insight on how you potentially can get funding and then go into protection and enforcement of your trademark.
Okay, thank you, Mika. Yeah, that's a lot of information. Hopefully, just a reminder, if we're going too fast or you're not following along, just please ask us questions during the session, or if you want to touch base afterwards, we're happy to answer any questions you have. And one that has come in is just why is it so slow? And I think it is an interesting point that, you know, the group of you who are listening here, Canadian businesses, are in essence have been put in the back of the line at CIPO. The legislation changed to allow the Madrid filings to come into Canada. So really internationally filed applications are examined on a quicker timeline. So Canadian companies who file through regular filing strategies are getting a longer examination time frame. And we do the strategies that Mika mentioned are really helpful, and they work to get things speeded up quite substantially. So that's the good news. So touch base if you have an application pending, it's been there for a long time, touch base with us and we can try to move it along. So let's get to funding. There is really an unprecedented amount of funding from the government for protecting intellectual property. And for some companies, technology is important, and you may want to protect your technology through patents. But you know, for most companies that are successful, and you have a name, which I hope you do, that name is important. And as you grow in success, the name becomes even more important. So protection is important, and the government, through their programs, recognizes that. So I just want to run through some of the programs and the funding that's available. And, you know, what I would say is talk to your business advisors or accountants just to make sure you qualify. But I can assure you that there is a lot of money at various levels, and please look into this if you're, you know, if you're interested in getting some help to put protection in place. So IPON is an Ontario-based funding program, and it provides up to $50,000, the 25% copay, meaning that if you contribute 25% of the total, the government will subsidize the amount. So it, you know, doing those analysis and searches and the actual filings is covered through this funding. The can export, it's a high, you know, for a company that already has revenue, it'll cover 50% up to $50,000 for patents and trademarks. The next slide.
Elliot, are you aware, so IPON is provincial. There's a question, are we aware if there are grants in other provinces that are
Yeah,
to IPON?
the next slide will have some other.
I don't know why it's not letting me go. Just one second. Oh, there we go.
There we go. Yeah. Oh, is this? Yeah. Okay. So yeah, there is through Elevate. It's a federal program, and it's offered through each province. So in essence, what's really incredible in my view is that for the IP strategy, that first level where you're just getting an opinion and doing searches, they will give $25,000, and it's not a copay. So it's a fully subsidized step just to assess your patent and trademark strategy. So and then the IP execution stage, which is the filing process, there's a copay of 10 to 30%. And these are available in Ontario. We've listed it. If you need the websites, we have those. We edited them out just because we thought we'd be here forever if we put too much in. So Ontario, Manitoba, Alberta, Quebec, the East Coast all have funding offered provincially for this federal program. And I believe it's IPON that the funding program is expiring at the end of March, and they're setting funding levels again for the new program. The understanding is that it'll be similar, and I believe Elevate, and I checked the main Quebec one, and I believe the entire Elevate program is continued through to 2026. So that's there. And I think that's really good news for all of you. And I would encourage you to investigate that. And you can talk to us and we can point you in the right direction. So yes, enforcement of trademark rights. It's important to remember that it's your responsibility. You have to do it. And if you don't, it can be pretty damaging. So how do you monitor the marketplace for infringement? The general rule is be proactive. There are things you can do without spending money on lawyers. You should think, who is likely to infringe your rights? Are you in a business segment where competitors are often poaching each other's brands and products? So we often, depending on the business, think about who are your top 5 competitors. Are they doing anything that offends your trademarks? What I would say is, on a regular basis, just go to a search engine, Google, and type in your brand and your product and hit search, and hopefully your company comes up. And if it doesn't, and someone else comes up, you should probably look very closely at who that is. And, just be careful and keep an eye on things, because I think it's an important point that when you achieve a level of success, there will be people who come into the marketplace and try to capitalize on your success, and that comes through many ways, but the easiest way is to capitalize on the value of your brand. So in a way, take it as a compliment. You've achieved success if someone's infringing your product. When you're not successful, or you're not making revenue, and you don't have a huge consumer base, no one's going to copy your stuff. But when you become successful, that's when people start copying you. So it's a good problem to have, I suppose. I'm trying to be positive.
I just
so
have
if
one
you-
note on the proactivity of
Yeah.
it before your next slide.
Yeah.
You can be proactive by marking your trademark. So if you have a common law trademark, you can put TM in the
Yep.
upper corner, like a superscript above your trademark. And if it's a registered trademark in Canada, you can put the R that's enclosed in a circle in a superscript above your trademark. And that's a proactive way to indicate this is a trademark, somebody's using it.
For sure. No, that's a very good point. So what happens if you, sorry, I just want to go back a sec. If you don't enforce, like if too many people are out there in the marketplace, you can lose rights to your mark. If everyone's using it and consumers, when they see your trademark, they don't think of your company, then your rights are lost. And remember, if you as you grow your business, you build a loyal client base and consumer base, and you care about them. And what would happen is if there's products or services out there that are trading under your brand, your customers get burned, and it hurts you, and you have to explain, well, that's not me, that's not us, and it's not a problem. So there's some real damage that can happen, and trademarks are the front line of that. So the first point is identify infringers, and you're going to think about targeting the weakest ones first if you see a lot of people, so you can build up a track record of success and knock out infringers. And then for the subsequent people you have to go after, you can say, look, we're going after people, we've already eliminated these people. And what I would say about the costs with enforcement, it's very important to remember it can get very expensive. Even those multi-billion-dollar brands can't afford to litigate every case. So settlement and dealing with things quickly and rationally is very important, whoever you are, however big you get. And that point about those industry leaders, you can go into the website of Brand Values, and go into your industry, see who those industry leaders are. One thing they all have in common is they all have enforcement programs. They're rigorous. They have different styles and aggression profiles of how they do it, but they all enforce their brands. I can assure you to make that list. So yes, so you found an infringer. It's really important, before you send that cease and desist letter, make sure you investigate the dates of first use, because it is kind of embarrassing if it turns out they were ahead of you and you just put yourself in a bad place. So just make sure that person came after you into the marketplace with that brand. Our job really is to set out expectations about costs as early as possible, and we want to make sure we're not trying to win fights. We're trying to achieve business goals for you, and that involves looking at your willingness to spend, your resources, and what your goals are. So when you talk to your lawyers, whoever they are, be sure you understand the costs and what the pluses and minuses are of the path you take. And if it's us and we're not doing that, let us know, let somebody know. That's really important to us. And we want to get your problem solved, and we don't want to win fights necessarily unless we have to. So the first step usually is a cease and desist letter. Hopefully you've seen some you know, if you've sent some, you know what they look like. You're basically setting out your rights, and then you're telling an infringer to stop using the mark and asking for where they got their products, how much they sold, all this type of stuff. And I'm sure some of you have got them, and that's generally not a good day when you get a cease and desist letter, but you can deal with that. We'll talk about that in a later slide. So if you don't get a response from your cease and desist letter, you can proceed to litigation. And we'll talk about that in a sec. But before you send your cease and desist letter, if it's an important brand and you want to take the most aggressive action on a cease and desist, you can start a court action and then send your cease and desist letter. And if you file in federal court, depending on where your defendant is, you have 60 days to serve your statement of claim. So in that intervening time, you can send your cease and desist letter, tell them you've filed your statement of claim, and that will create some incentive from that infringer to settle. So that's a way to go that's a very aggressive way to do it. And in certain situations, we do recommend doing that. So next slide. If it is so expensive, why would you litigate? You can get lots of good results just from settling. So what I would say is, in some cases, you may want to consider litigation. The outcomes from litigation to go to all the way to trial is very rare. That's the bottom line. I don't know how many actual cases go to trial in Canada for trademarks and patents, but it's a shockingly low number. Maybe we could get that to you. The outcomes are a permanent injunction. That's a very good one, just to get them to stop. Cost awards, that only covers a fraction of your legal costs, and you can get money. But you can get all those things from settlement often and quicker and with certainty. So why would you litigate? I think one thing to remember is, if it's an important brand, this is a very good reason to litigate at least once, because then maybe you won't have to in the future. If you get a judgment against an infringer for your most important brand, that judgment can be used to show others that you are not bluffing. You are going after people. You take your IP very seriously, and a lot of companies send cease and desist letters, and a lot of companies ignore cease and desist letters. If you are a company that's perceived as one that might take it to litigation and follow through, then people are going to take you seriously. So that's one reason. And again, it's our job to make sure you understand what the costs are, and whatever they are, it is expensive to litigate. But in some cases, when you become successful, it's important to do it. Let's keep going. So talking about places where there is infringement, online marketplace, that a lot of people are doing business through places like Amazon or Alibaba or Etsy, those types of things, and social media. They all have their own programs, and Amazon has a very well-known program. And the question is, how do you use it? It's a quick way to get infringing products off the Amazon platform. So do you need a registered trademark to join the registry? The answer is yes. And one of the criteria to accelerate an application to get it registered very quickly, like they'll examine it within a month, I think, is at CIPO, you can file an affidavit just saying that you're being severely disadvantaged. You have an Amazon platform, you're using the Amazon platform, and you're being disadvantaged. And what we're seeing is that's enough to get advanced examination. So it's if you want to take advantage of the brand registry, you can. And there is an IP accelerator program. And if you use Accelerator IP Lawyers, Amazon's group, you can get on the brand registry once the application is filed. So there's that as well. And someone had a question about, can you, regarding Mika's comment about common law rights, can you acquire common law rights through selling products on Amazon? And Mika, if you want to answer that, you can. If not, I'm happy to answer that quickly.
Yeah, if you're selling through Amazon in Canada using your trademark, you can gain common law rights in Canada.
Yeah. And I think that would extend, so where you have sales, so through the platform, if they're where the location of the consumers are, and it would come down to a question of fact, whether you're establishing a reputation in that area through sales through the platform. So if you have thousands of US based customers in a specific part of the US, then you could be successful there through Amazon. So, okay, next, another nifty little thing you can use, the Canadian Border Services Agency is available to help with infringing products coming into the country. So if you're a company that you're worried about infringing products coming in from other countries, if you get a registered trademark, you can, there's a request for assistance form that's offered through the CBSA, and you fill it out. It's very easy to fill out. We help people do this all the time. It sets out what your goods are, talks about who your authorized importers are, what their addresses are. If you know of the illegitimate sources, you list those. And it gives you a chance to meet with customs people, customs officers. They're very helpful, and you can have a meeting and discuss your products and what you're worried about. Once your request is approved, they will intercept any suspected counterfeit goods and call your representative, and often that's a firm that you choose, and then you're given the opportunity to take action. And if they find stuff, it's referred to the RCMP, and if there's criminal activity involved, they will, they'll take action, and that can be a very effective tool at dealing with issues. Okay, so defending your mark. If you get a cease and desist letter, I know we're running out of time. I'll just blast through this. It's important. Don't panic. There's lots of things you can do to keep using a mark. If you receive a cease and desist letter, someone says you're infringing our products, you've got to look very closely at who sent that letter, what their dates of first use are. You look at, are they actually using it? Is the person, often it's the person who sent it might be a licensee or a distributor, and they may not have technical rights to the mark in the country, thereby creating some vulnerabilities. And there's very simple processes to cancel someone's mark. So we send cease and desist letters, we receive them and help respond. We know how to deal with this. There's ways to do things. So we're looking for solutions. We're looking for ways out of situations. Remember that when you get a letter, if the mark is being used by you and many other third parties, as I mentioned before, that person who sent the letter, they may be vulnerable to a loss of distinctiveness of their brand, and you could invalidate their trademark. So the bottom line is, when you get that letter, it's generally not a great thing, but there's, in the vast majority of cases, there's a solution, and we are here to help you with those. So next one. Okay, so I put this slide in just for people who are selling products in Quebec. You're probably familiar with the French laws about marking products. There's an important change that's coming in June 2025. So I just wanted to bring that to your attention. Going back a little bit, just that for packaging and products, things must be in French or French in another language. Yeah, I guess we'll go through that. But the bottom line is there's a recognized trademark exemption that exists now that applies to those common law trademarks and registered trademarks that Mika mentioned. And in June, the scope of what is a recognized trademark that does not require translation, it will be restricted for inscriptions on products to only registered trademarks. So if you are using a trademark in Quebec that is on products or on public signage, it's important to actually get it registered. And CIPO is trying to push through, I guess, they're trying to get caught up so that businesses aren't prejudiced by this change in legislation. There's a few other rules about if there's generic terms in the trademark, you will have to translate those. Previously, people might have been using this trademark exception to sneak some generic words to avoid translation requirements. So when you get this presentation sent to you, I'd say read through our slides on this because we're running out of time. So I want to just talk briefly how this is something I really care about and get excited about when I deal with companies, is how it's very important for you all to educate your employees, your marketing team about how they can help you and how you can help build your brands and keep them strong. So the bottom line is, I've seen all the bad things that happen when you don't follow this list of rules, but make sure you choose a clean trademark, that being one that isn't already used by a third party. I see lots of times that, the people running a business are really tied emotionally to a brand. They want it. They don't care someone's already using it, but it just becomes a problem and it never goes away. So try to choose a clean one. And for your marketing people, really remind them to clear things with your legal department before they do things. I know that often doesn't happen. And as Mika said, with trademarks, mark them properly. The TM can be used on anything you think is a trademark. The R circle is anything registered. Again, what I say, I'll say it if I can say it as many times as I can. Look at those industry leaders. Go to their website. How do they do it? How do they mark things? How do they have branding guidelines? Look at those branding guidelines. What do they look like? What are they doing that I'm not doing? Just as a sanity check. Remember, when you're using them, use the trademarks properly. So yeah, right now there's March Madness going on. And anyway, just if that's a trademark, that's the basketball tournament. So if you use it wrong, it becomes synonymous with the product, and then it can lose its value as a trademark, and it becomes genericized. That's happened to a bunch of marks, like elevator, escalator, all these things, thermos, those types of things. And I'd say, again, look at your business partners, make sure they're using things properly. Social media. Yeah, the point being that there's infringers and you should be aggressive with them, but often your fans, your consumers are talking about your mark and they're not doing it in a proper way, you should be nice and like get them involved in policing your brand rather. Like make sure they use it properly, but just be nice to your fan base, your consumer base. And as I've said, study industry leaders, see what they're doing. And the final point, yeah, if you have any questions, just talk to us. We're happy to point you in the right direction. And we want to help you build your brands and be on that brand list with a big giant circle one day. So, and now I guess it's time to go through some questions. We only have a
good
few
time
minutes.
for us to answer some of those questions you said you
Yeah.
can ask us.
Yeah, sorry, I knew we'd go along too long, so sorry about that.
I think some of these we can rapid fire. Yeah.
Is there a Quebec equivalent to IPON? Someone asked. The answer is that through Elevate IP, there is funding through in Quebec. It's through Maine QC, I think. If you want, we can send you the link. At what stage is what? Okay.
Next
Yeah.
question is asking, what stage does one need to engage with the granting programs?
Yeah. On these funding programs, it's a good question. I think why don't you touch base with us? I think some of them, like I know with IPON in particular, there's some deadlines that most IP firms are dealing with right now, and it's like some of the funding's expiring. So I think for Elevate, it's an open program. We can walk you through your specific situation. So I would say come by. Contact us and we can figure that out.
What would happen if a registered trademark, both Canada and US, is only used in the US but not in Canada? Well, you risk losing your registration in Canada. You can have a registered trademark without use in Canada, but someone can come forward and with a cancellation proceeding and cancel your trademark. Just given the time, I think we can read through these quite quickly and hopefully we cover them substantively. So from experience, how long does the process take to acquire C&D letter from a lawyer? Once all the evidence has been provided, it can be quite quick. We've done C&Ds from as short as like a day and a half to 2 or 3 weeks, depending on your necessity. Should you put a trademark at the bottom of your website? It's a good idea, hey, Elliot?
I think so. I think you're like the TM symbol, put anything you think is a trademark that you think is distinctive, you could mark that with a TM. And if you have a question about that, just give us a call. We, show us what you're talking about specifically. We can say, this is how you should do it. And again, look at industry leaders. How do they do it?
And put your trademark everywhere. So like you can put your trademark with the TM on your website. You can put it on your videos. You can put it on your goods and services. Put it in as many places as possible to notify your consumers that this is your trademark, this is your brand. You want to build brand recognition. So flagging it with that TM and putting it on all these different goods and services is a great idea. So hopefully that captures both of your questions, Jim, Doran.
Someone's asked a question about Quebec, and there are, about the changes coming in June. Certainly they are in flux right now, and there's some talk about relaxing some of the current positioning on the recognized trademark exemption. So like the point of that slide is stay tuned and keep an eye on Smart and Biggar and we have a large and robust Quebec office, and we have experts who will be right on top of that, speaking with the Quebec government on the latest. So we'll keep you posted, but definitely there's some movement. We're trying to restrict things.
We're also talking with CIPO, or we have suggested to CIPO to make it a basis to get an expedited examination if you're working in Quebec, but their answer is very vague right now. Next is, if the process in Canada is very long, then what to do if we need to hurry? So there was a slide on this. There are a couple ways that you can expedite your exam. So if you just take a look at the slides when you receive them, I would suggest reading that one. I just see that we're out of time and I just want to answer, do we have time to answer a couple more questions? How much does Smart and Biggar charge to issue a C&D letter? It's going to depend on the complexity of your issue. The simpler the issue, the smaller the cost. I can probably do, and it also depends on who does it. Elliot is a principal and I'm an associate. So our hourly is a little bit different. So I would ask whoever you are working with first, what the charge can be, because it's really going to fluctuate.
Yeah. On that point, I would say the more work you do, the more background work that I talked about on my slides, like tell me who's out there. What we're going to look at, who is the infringer? Are there others out there in the marketplace? All those dates of first use, that if you give us that helps keep the cost down.
Yeah, for sure. If we handle your registration of your trademark, yes, you will be advised prior to potential expiration or renewal requirements. We keep you up to date. So we have those dates in our calendars and we let you know when a renewal needs to occur. And I think that we might be out of time now.
Yeah, we're over time. So yeah, there are a couple of questions. We'll try to get to those with an email. And I thank you, and please do touch base if you have any more questions. And you know,
yeah, I really appreciate the engagement. Love the questions. Thank you so much.
Yeah,
and
our next,
feel free to email either of us. We love answering questions and
yeah, for sure.
Clients.
And just our next the next webinar in the series will be tips and tricks on Canadian and US trademark prosecution. So stay tuned for that, and hope you enjoyed this session, and please reach out and let us know. Thank you.
Thank you so much, everyone.